At the end of our last hour, we were going to look at whether or not a state regulation has interfered with interstate commerce too much. First, of course, we must decide whether or not the state is regulating commerce. Not everything is commerce. An activity is interstate commerce under either the cumulative effect doctrine. This is the Wickard versus Filburn wheat case that I'm sure you know about. And also it is interstate commerce, an activity can be interstate commerce under the substantial economic effect doctrine, which says that if the activity has a substantial economic effect on more than one state, then that's a substantial economic effect on the national economy, and that is interstate commerce. One of the key cases in that case is U.S. versus Lopez. That's the gun case, where the state rules said you can't have a gun within, or ex-felon or someone can't have a gun within 1,000 yards of the school, and the court said that regulation really didn't have anything to do with interstate commerce. It didn't require that the gun had traveled in interstate commerce, had been sold in interstate commerce, or anything. It did not have an appreciable effect on interstate commerce, so a substantial effect on interstate commerce. So the conclusion here is, what is commerce? An activity where the cumulative effect, it has a cumulative effect on interstate commerce, the wheat case, or if that activity itself has a substantial economic effect on interstate commerce. If the state is regulating commerce, then the question is, did the state interfere with interstate commerce too much? After all, the federal government has the right to regulate interstate commerce as much as it wishes. And if the state is going to pass a law regulating the speed of interstate trucks on the highway, for example, interferes with interstate commerce to some extent. And the question is, did it interfere with interstate commerce too much? Now, to answer that question, we come to our interstate commerce analysis. First, the market participant rule. If the state is simply participating in interstate commerce, that by itself is not even regulating interstate commerce at all. If the state has a shoe factory, and there are lots of other shoe factories in the state probably, in any case, the state is simply participating in the market as a shoe factory. The state can decide, just as a private shoe factory owner could decide, we want all of our leather for this shoe factory to be purchased by, from ranchers that are within 100 miles of this shoe factory. Well, a private owner could do that, and the state can do that. That is not regulating what other people do. It's simply saying, here's what we want to do. So if the state is merely a market participant, that is not regulating interstate commerce at all. But if the state is regulating interstate commerce, we look to see if the regulation discriminates against interstate commerce, not discriminates against something else. People have often thought of this as discrimination in some other way, but we only are talking about interstate commerce. If the state regulation discriminates against interstate commerce, strict scrutiny is applied. That is, the state regulation must be necessary to a compelling governmental interest and no less burdensome alternative. If the state regulation gets past this test so that it does not discriminate against interstate commerce, then if there is no discrimination, we balance. Now, this balance is under the Cooley Doctrine, C-O-O-L-E-Y, the Cooley Doctrine. The Cooley Doctrine says that if, first of all, acknowledges that when that almost any local regulation of interstate commerce has some impact, but it is necessary to allow some local regulation of interstate commerce. For example, an interstate truck comes through your little town and there's a stop sign. Well, you want the truck to stop at the stop sign like everybody else. It goes past a school and there's a sign that says school zone, speed limit 15 miles an hour. You want the interstate trucks to slow down too. And, even if they're not on the highway, you want them to slow down. And so the point is that it is obviously very convenient for local governments to exercise some regulation of interstate commerce. But when that regulation, if you regulate for your local purposes more and more and more, at some point the regulation of interstate trucking or whatever the interstate commerce activity is, you regulate enough and it begins to interfere with interstate commerce too much. So when has the state or the local government regulated so much that it is now that you put an end to it? You say, nope, you local government, you can't regulate any further than that. It goes too far. Okay, that is the so-called dormant commerce clause, the commerce clause that sort of limits how much the local governments can regulate interstate commerce. The dormant commerce clause is kind of like the idea that implied is a limitation on how much the local governments can regulate interstate commerce. So in order to do that, what we do is we say, okay, the local governments can regulate for interstate commerce, but when they regulate too much, it violates the Commerce Clause, and the question becomes, how do you decide that too much? In the balancing test, right here under the Cooley Doctrine, what we do is we look at the state interest in interstate commerce, and we look at the federal interest. And we say, if the state interest is outweighs the federal interest, then the balance is okay. If the federal interest outweighs the state interest, then the regulation is not okay. How do you measure the state interest? How do you measure the federal interest? Well, the state interest, you look at these three factors. The importance of the state interest, the likelihood that the state will be able to achieve its purpose, and does the state have alternatives? Let's look at the first of these, the importance of the state interest. Well, the state interest can only be one of four possible interests because the police power allows the state to regulate for health, welfare, safety, and morals. If the state is regulating for health or safety, that is considered a very important state purpose. And so the state interest gets a lot of points if they're regulating for the health or safety of the citizens of the state. If the state regulation is regulating for the economic benefit, in other words, welfare of its local people, that's not given such high points. The likelihood that the state will be able to achieve its purpose. Well, if the state is regulating for safety, then you look to see if the state regulation is likely to produce very much safety. And for this, you would turn to any studies that the state has done, hearings that the state has conducted to determine whether or not this particular regulation would have a significant impact on whatever the state purpose is. For example, there was one bar question where the state held hearings and determined in the hearings that there was too much lead in the air and it was causing a health problem. Well, if there's too much lead in the air and it's causing a health problem, the state then passed a law saying you can't use high lead gasoline in trucks in the state anymore. Well, that certainly is a rational way to promote health. So in that case where you can't use high lead gasoline in trucks anymore, the importance of the state interest is promoting health, and the state law, pardon me, the state law regulating the use of high lead gasoline is certainly rationally related to promoting health, and the state is likely to achieve some of its results. If you stop the trucks from using high lead gasoline, they will reduce the lead in the air. So you had an important governmental interest and a substantial likelihood that it would be achieved. The third factor is, does the state have alternative ways to achieve its goal? If the state has other ways to achieve the goal, which do not interfere with interstate commerce so much, then the state should certainly consider those. So if the state has alternatives, that reduces the importance or the credibility of the state interest. So to evaluate the state interest, we look at these three factors. Alternatives, in writing your answer to the bar question, you can almost always find some alternative way that the state might be able to achieve a similar result. The alternative may not be so attractive, and you may dismiss it because of that, but give them some alternative. That's how you weigh the state interest. You compare that against the federal interest. The federal interest is simply in the free flow of commerce. So you look at how much does this state law interfere with the free flow of commerce. There's no special rule or anything. You just write some descriptive material about how that would happen. For example, in the mud flap case that I'm sure you are familiar with, the state law in Illinois said that if you're going to go through this state with a truck, that the mud flaps that are intended to keep from throwing mud upon the windshield of the cars behind you, snow particularly when you're driving in the snow, so these mud flaps on the wheels of the trucks, the state said you must use a certain shape contoured mud flap. And the truck drivers said that rule that we must use this particular contour of mud flap interferes with interstate commerce too much, that it is unlawful. And we, the truck drivers who have to change our mud flaps to comply with your new Illinois state standard, that we have standing because we are the victims of this unlawful requirement that violates interstate commerce. So when the truckers sued, the state said, oh, we have an important interest. We're promoting safety. Well, okay, that's true. Likelihood of achieving it? Well, the truckers said, your mud flaps really, this funny contoured mud flap, really isn't any better at protecting people behind us than the mud flaps that we've used all over the rest of the country. So there was a dispute as to whether or not the state would be likely to achieve its desired results. And finally, does the state have alternatives? Well, the alternatives to the new mud flaps are the old ones, if the old ones are doing just as good a job. I might also point out that in that case, the Supreme Court was also influenced by the fact that the company that manufactured this special contoured mud flap, one of the primary owners was the Speaker of the House of Representatives of the state of Illinois, and so it looked like some kind of unfairness going on there, and ultimately the truckers won. But the government wishes to have the free flow of commerce, so the state interest wasn't all that great because the likelihood of achieving the results wasn't great. The state has alternatives that do just as well. So the state interest wasn't all that great, and the truckers said this was a dramatic interference with the free flow of commerce, because according to the truckers, if you're driving your truck, when you get to Illinois, a lot of the truckers didn't like those mud flaps. So when they got to the Illinois boundary, they had to stop their truck, get out in the snow and mud, take off the regular mud flaps, put on the special ones that Illinois wanted, then they could drive across Illinois and take them off after they left because they didn't like them. And so it was a dramatic interference with interstate commerce. So that's how you would weigh these. This also came up in a case where the court was requiring, not the court, but the state was requiring the trucks to not use high lead gasoline in that state to promote health. Well, the state law says don't use high lead gasoline. The importance, yes, health, very important. Likelihood of achieving some of it, yes. If you stop the trucks, you will reduce the lead in the air. Does the state have alternative ways to reduce the lead in the air? Certainly, you can think of an alternative. For example, the state could pass a law that simply said, you can't buy high lead gasoline in this state. Just stop selling it. So nobody would be able to use high lead gasoline anymore. That's another way to reduce the lead in the air. You may be able to think of some others. So the state interest is somewhat significant, but since there are alternatives, well, you know, say what you want to. It isn't so important what label you put on the state interest. The important thing is to describe it. Then how much does that interfere with the free flow of commerce? Well, the truckers would say, when I come to your state with high lead gasoline in my truck, I have to stop, empty the gasoline tank, put your kind of gasoline in before I can drive on. Now, if it's a small state, of course, it isn't going to make any difference. They can fill up and not, I mean, if it's a small state and the state passes a law that says you can't buy high lead gasoline here, that wouldn't make much difference because the truckers would just buy it before they got there. But if it's a big state like Texas where you're going to run out of gas before you get through the state, then saying you can't buy high lead gasoline would have a significant effect, would be a reasonable alternative. So in any event, the truckers, the interference with the free flow of commerce is that the truckers would have to empty their gasoline tanks when they got to the state, and that would be a major disruption. It doesn't matter how you come out. Describe the disruption of interstate commerce, describe the state interest, and make any conclusion that you want. That's how you do these Commerce Clause analysis problems. Now, what I would like to do is to use what we have learned to analyze some bar questions. We will analyze the bar questions that I mentioned to you that we would start with. These three bar questions, we would like to use what we have learned to analyze these three bar questions. And we will start with this one, July 96. That July 96 question is the Lead Poisoning Prevention Act. That question reads as follows. The first, now I'm assuming that you have read the question, but also I will read the critical parts, not necessarily every word. It says, to lessen the exposure of children to lead poisoning, Congress passed a Lead Poisoning Prevention Act to be administered by the Federal Housing and Urban Development Agency. That's a federal agency that's going to administer this law called the Lead Poisoning Prevention Act. That law says that if you this law requires that owners of residential housing, including all state and municipally owned public housing. Careful now, state-owned public housing, you know what that is. Municipally owned public housing, you know what that is. The state, so whether it's owned by the public state or owned by the public municipality or owned by an individual, says in all of those cases, if the house was built before 1965, when lead-based paint was banned, that you got to test all of these dwellings for lead paint, and if you find lead paint, you got to take steps to get rid of it. That's what the federal law says. And it applies to housing, whether it's owned by an individual, or owned by the city, or owned by the state. The next paragraph says, the Lead Poisoning Prevention Act requires each state to designate a state agency to enforce the law. And it tells you what kind of damages and so forth you can get for from people who violate the law. But the key point here is that the Lead Poisoning Prevention Act requires the state to designate an agency, a state agency, to enforce this federal law. Do you see the problem? The problem here is that the federal government is probably violating the 10th Amendment because they are invading the sovereignty of the state. The federal government is invading the sovereignty of the state because it's telling the state, here's a law and we want you to enforce it. Well, if Japan can pass a law and tell California, you got to enforce it, what kind of sovereignty does California have? So if the federal government can make the states enforce the federal laws, that invades the sovereignty of the states. Now we see that in this problem where sorry, it's on the next. It's on this one here. The question is, did the state law violate the Constitution? Was the state, pardon me, this is the federal government, the Federal Lead Poisoning Prevention Act. Did it violate the Constitution? Well, was the federal government authorized to, was the federal government authorized to do what it did? Pass the Lead Poisoning Prevention Act. This is the legislative body that did this. What is the authority of the legislature body? It has the power to create post offices, to create armies, to do all kinds of things that are in Article 1, Section 8. But out of all of those things in Article 1, Section 8, nothing seems to fit giving the state the authority to make people remove the lead paint from their buildings. Nothing fits very closely. The closest you can come to that is that maybe the Commerce Clause gives the federal government the power to make people remove the paint from their housing. The way you would make that argument is that people travel interstate, they move, and they take their children with them. And if children crawl around on the floor, and if the paint is peeling off the walls, the children will eat the paint. And their brains will be damaged as a result of that. And so the federal government can say, we want people to be able to travel in interstate commerce, to be able to move freely from state to state, and in doing so, to not have their children harmed by eating lead paint. And this is particularly true of housing that is owned by the state or the city, because that's more like that public housing is more likely to be not as well and upkept and so forth, and the paint's more likely to peel. So therefore, the best argument we can make for the state having the authority, for the federal government having the authority to make people take the lead out of their paint is that maybe it's under the Commerce Clause. So the legislation may or may not be lawful, but if you succeed with the Commerce Clause argument, they have the authority to do it. Now the next question is, did the federal government go too far? Well, we're not talking about individual rights at the moment. There aren't any involved in this. But did the federal government go too far against the state? They are requiring the state to enforce this federal law. That invades the sovereignty of the states too much. So the Lead Poisoning Prevention Act is probably, it may be void because it may not be any authority for Congress to do it. If you do get past this, did the state go too far? probably did by violating the 10th Amendment. So let's continue. Next paragraph, third paragraph. After passage of this federal law, the Attorney General of State X filed a suit, and the suit said three things. Number one, it alleges that Congress lacked the authority to enact this regulation. Well, that's what we just talked about. Where did Congress get the authority from? We're not sure they have it. Secondly, the State Attorney General said, in any event, it lacks the authority to require the individual states to enforce it. There's your 10th Amendment, invading the state sovereignty too much. Third thing that the State Attorney General says that Congress lacks the authority to regulate the state and municipally owned housing in this way. Can the federal government, when you have the state owning housing, can the federal government tell the state what to do with this housing? Can it tell the city what to do with its housing? Is that invading state sovereignty too much? And the answer to that is that's probably okay. Because if the federal government is acting under the Commerce Clause, the federal government can obviously require individuals to do certain the federal government can regulate interstate commerce, and so it can regulate trains, airplanes, buses, can regulate the channels and facilities of interstate commerce, bus stations, airports, and so forth. So the federal government can regulate interstate commerce, but suppose that the train that the federal government wants to regulate is owned by the state. Suppose, for example, as in a real case, you have a state owns the, at a loading dock, a ship loading dock, the state owns the little railroad company there that takes stuff off the boats and puts them onto boxcars. Then they push these boxcars off onto the main railroad tracks so that they can be taken any place across the country. And the state owns that little railroad company that loads the boxes on and off of the trains. Well, if the federal government passed a law regarding hours and wages of train employees, because they are engaged in interstate commerce, they can regulate those train employees even if they are working for the state. So even if the state is engaged in interstate commerce, if the federal government wants to regulate interstate commerce, doesn't matter whether it's the state that's running the railroad or an individual. The government can regulate it. And likewise with the housing here, it doesn't matter whether the state owns the housing or the city owns the housing or individuals own the housing. If the law is enforceable under the Commerce Clause, if it's enforceable against an individual, it's enforceable against the city, and it's enforceable against the state. The final part of this problem is that a woman named Ida wants to intervene because she says she wants to intervene on behalf of the state, and she wants to intervene on behalf with the state on the theory that the state says the federal law is unconstitutional. She wants to join them. She wants to intervene on the theory that she is about to buy, she's planning to buy some housing, an apartment building, and this apartment building will be subject to these new federal regulations. But she doesn't own the apartment building yet. And HUD, the federal government that's being sued here, says we don't want Ida to intervene because she does not have standing. So you had to determine whether or not Ida had standing. And you would go here to the standing rules, and you recall that Ida, the individual, wants standing. 3 requirements. She must show injury in fact. Well, she hasn't shown injury in fact because she doesn't even own the apartment building yet. If she doesn't own it, she would have to show imminent, that the harm was imminent. And the facts don't show that she was that close to buying the apartment building. So her harm has not happened and does not seem to be imminent. Therefore, you don't have causation and redressability. Well, you can say causation. If she had been injured, it would be she was injured because of the federal regulation. And if the federal regulation were eliminated, then that would redress her problem. So causation and redressability would be okay. I just don't think that she has shown that she has been injured yet. That's how you would analyze that question. Let's look at the second question, the February 1991 question. In the February 1991 question, this is the question dealing with city, OUTCO, INCO, and NAWT. NAWT is the National Association of Waste Truckers. In this problem, February 91, the city is a municipality in State X, and it owns and operates a landfill for household and commercial waste disposal. The city finances this operation by charging fees based on a rate formula involving the weight of the waste. The city landfill is relatively new and has substantial unused capacity. Now, please notice that the city created this new landfill, and anybody can create a landfill. You don't have to be a public entity. Not anybody can operate a police department. Not anyone can operate a court system, but anybody who wants to can create a landfill. And so when the city creates a landfill, it's simply a market participant. It's participating in the market of providing a place for people to dump their stuff for money. So the city is simply a market participant so far. Nothing they have done is attempting to regulate interstate commerce. They're just participating in a business activity. Second paragraph, OUTCO is an out-of-state trucking firm. Out-of-state trucking firm. So this trucking firm isn't even located in State X. It's located someplace else. Obviously, it's going to be hauling waste into State X, into this landfill that's owned by city. But the trucking firm is located outside of State X. So OUTCO is an out-of-court trucking firm that's engaged in hauling these waste products and has entered into contracts with various out-of-state cities to transport their waste for disposal to cities' landfill. Well, so this OUTCO company is hauling goods, hauling waste into State X and into this city landfill. Well, there's nothing wrong with that. OUTCO is obviously engaged in interstate commerce, is hauling things from one state to another, and even under the oldest version of interstate commerce, that is engaging in interstate commerce when you're traveling, hauling stuff from state to state. So OUTCO is clearly engaged in interstate commerce, hauling things, and please notice that OUTCO has contracts with various people to pick up their waste and take it here and dump it. Well, we know what's going to happen because you read the problem already. City is going to increase the fees for out-of-staters. And well, and it's going to, I think it prohibits the out-of-staters altogether. Let's keep reading. It says here that there's another company called INCO, and INCO is a State X trucking firm. So INCO is located inside of State X, and it also hauls stuff to the dump site from various places inside of State X. They haul things from inside of State X and outside. In other words, INCO hauls stuff to this city dump, and it picks up stuff in the city, it picks up stuff outside of the city but inside of State X, and it picks up things outside of State X. So it picks up things from all over and takes them to this city dump. So we've got these two companies, INCO and OUTCO. Outco is the non-resident. Third paragraph. City has recently enacted an ordinance banning disposal of out-of-state waste. Whoa. So the city just said to Outco, you can't bring your stuff here at all anymore. And that is clearly, is that interfering with interstate commerce too much? Well, let's take a look. First of all, you know the New Jersey, the Philadelphia garbage case, where the city of New Jersey said other people are bringing their garbage to our city, bringing it here to our state, and we're passing a law saying you can't bring your stuff here anymore. And Philadelphia, the city of Philadelphia, was one of the cities that was hauling stuff to this waste dump in New Jersey. And the Supreme Court says no to New Jersey. You can't stop this outside traffic coming in there just because you want to keep the landfill for yourself. That you're trying to protect your environment, perhaps, and save some landfill for yourself. And for these purposes, you're trying to stop interstate traffic. And that's interfering with interstate commerce too much. Let's look at the way you would analyze that. You would analyze that by saying, did this New Jersey law interfere with interstate commerce too much? Well, if they're telling trucks you can't bring stuff in, that certainly is interfering with commerce. Is it interfering with commerce too much? Well, in the New Jersey garbage case, we'd see, first of all, the state was not merely a market participant. The state is a market participant if they own the garbage dump, but they don't regulate other people. They just operate their garbage dump. But if the state is passing a law saying what other people can do, that's not a market participant. They are a market regulator. If they're regulating, do they directly discriminate against interstate commerce? Well, I think so, because they are picking out interstate commerce and saying you can't bring it here anymore, directly discriminating. Apply strict scrutiny, New Jersey will probably lose. Even if they didn't find that that was discrimination, you'd go to the balancing test and the state interest would not be sufficient to interfere with interstate commerce that much. Now, in our case, the state has our city has said no more outside waste can come into our city-owned dump. Well, it's just like the New Jersey garbage case. The city cannot interfere with interstate commerce that much. First of all, it's discriminating against interstate commerce. If you didn't think it was discriminating, go to the balancing test and the city would lose. Continuing, please notice, by the way, that the city is a market participant with regard to simply opening up a city dump like anybody else can have a dump. The city is just a market participant. But when the city uses its police power to regulate what other people do, you can't bring your waste here anymore. When the city does that, they're now regulating. And so that's why they are a regulator, and what they did violated the Commerce Clause. Continuing, so the city's rule that says Outco can't bring their waste there anymore violates interstate commerce, no question about it. Also, they mentioned that this Outco had contracts with other people to pick up their waste and deliver it to this city dump. And so you could make a contract clause argument, that is to say, the waste company that can no longer bring their stuff to the city dump will say, we have to take our stuff somewhere else now. This is Outco. And Outco says, we have to take our place someplace else. It is more expensive, and we're now going to lose money on these contracts that we have, and we claim that the city is violating the contract clause. Well, that's kind of absurd. To violate the contract clause, the city regulation or the governmental regulation has to have a has to be directly aimed at the contract itself. simply passing a law which has an indirect effect on lots of people's contracts is not violating the contract clause. Now, dealing with INCO, we now continue, and it says, we know what happened to OUTCO, and it goes on to say that for INCO, they impose a new rate fee so that if the INCO picks up waste from the city, they pay the regular fee. But if they pick it outside the city, even though they pick it up inside the state, if they pick it outside the city but inside the state, then the fees for using their dump is doubled. Well, we don't have, in that case, let's be sure the facts are clear. The city passed an ordinance that says to INCO, if you pick up waste within the city and take it to our dump, usual fees. If you pick up waste inside of state X, but outside the city, we're going to charge you double. And if you pick up stuff outside the state, you can't bring it here at all. Well, not bringing it here at all, we know about that. That violates the Commerce Clause. That discriminates against interstate commerce. But if you pick up stuff outside of the city but inside of the state, that would still be viewed as discriminating against interstate commerce and would violate the Commerce Clause. However, city might say, but we are a market participant. We are a market participant. We can charge whatever fees we want to. If we were a private company and we wanted to charge people new fees, we can charge anybody any fees we want to. And so if we are simply a market participant, we're not saying to INCO, you can't bring your stuff here. We're saying to INCO, we're going to charge you more money if the stuff came from out of state. Well, if a private, out of the city, pardon me. Well, if a private company did that, it would probably be okay. A private company can charge these people whatever they want to. They can, but the city did this by the use of its police power. It passed a city ordinance to this effect. And so it seems to me we may have a problem because they are regulating, they're using their police power to regulate. They're not just, it isn't so clear. The waste that comes from outside of the city but inside the state, if a private party wanted to charge them more, they could do that. If the city wants to charge them more, maybe they could do that. But the city used its police power to do that. And when it uses its police power, they said they passed an ordinance to that effect. Using its police power is in effect regulating regulating interstate commerce. So I really suspect that would be, because they use their police power to do what they could have done otherwise, that it probably violates the Commerce Clause. The final question here is, does NAWT have standing? That's the National Association of Waste Truckers. That is your associational standing. Associational standing, to have standing as an association. Now, NAWT is representing the truckers. So remember the requirements for associational standing. The purpose of the association must be germane to the lawsuit. Well, that's fine. This is like the union representing their members. Secondly, at least one of their members must have standing. We probably have that because at least one of their members is out of state and they can't bring their stuff in. And finally, they do not need the participation of the individual members because because all they want is a declaratory relief or an injunction. They're not looking for damages. So they do not need participation of any individual member. And that's how you would analyze this problem from February '91. And we now go to the problem from July 1980. In the question from July 1980, this is Ajax, Ned, and the special driving permits problem. Now, I need to tell you that this problem not only has Commerce Clause issues in it and Supremacy Clause issues, which we are prepared to deal with, but it also has some equal protection and privileges and immunities issues in it. And we haven't talked about that yet. By the way, the last problem that we just dealt with, you might argue that maybe the city violated the Privileges and Immunities Clause because the Privileges and Immunities Clause says that you must treat the non-residents just like you treat the residents with respect to basic rights and essential activities. Well, the city isn't treating out-of-state people in this waste problem we just did. The city wasn't treating out-of-staters any different than it was in-staters. They were treating the trash, the garbage, differently. They're saying if the garbage is from out-of-state, you can't bring it here. If the garbage is from in-state, you can bring it here. So they're not treating people differently depending on their residence. They're treating the garbage differently depending on where it came from. The Ajax Net Special Driving Permit problem, let's take a look at it. The legislature of State A passed a law requiring drivers of trucks carrying high explosives on the roads in State A to have a special driving permit. These permits are to be issued only after very vigorous physical examinations of the driving and a driving test. Well, that's okay so far. If you want to drive high explosives in this state, you got to have a special permit for doing it, and we're going to make you be sure that you're healthy and strong before you do that. Continuing, it says, the State A law also provides that, by the way, this State A law that I just mentioned, requiring drivers to have a special driving permit to haul high explosives, that State A law is not void for a violation of substantive due process, because the right here, substantive due process, does this state law requiring a special driving permit, does that violate the Constitution? Well, if the state law is irrational, it might, but this state law is a rational way to promote health, welfare, safety, and morals. Saying that people who drive high explosive trucks must have special driving permits and then make sure these people can drive safely, that promotes safety. And that's a rational way to promote safety, and therefore the state did not violate substantive due process. Let's continue to read the problem. The problem says, the State A law also provides that only State A permits issued by State A are acceptable for driving these trucks. Well, now that's a problem, because it means people who are passing through their state, hauling high explosives, that those people can't go through the state anymore unless they stop at the border, go to town, do what they have to get this special driving permit. Medical exams, driving tests, and so forth could take them days. And then once they get the special driving permit from State A, they can go back to the border and get their truck. Now they can drive it through State A. Well, you can see that that is a dramatic interference with interstate commerce. And it's going to take a lot to justify that much interference with interstate commerce. But let's keep going. So you got to have one of these permits to drive high explosives in State A. It says that you can't use any other state's permit because the other states have less stringent requirements and they are not acceptable in State A. Continuing, under the State A law, such permits, these permits to drive the high explosive trucks, cannot be issued to persons who are under 30 or over 60 years of age, because statistical studies have shown that drivers in these categories have higher accident frequencies. And so it's clear from that this state law is a rational way to promote safety on the highways. And since it's a rational way to promote safety, this state law does not violate substantive due process because it's a rational way, right here, it's a rational way to promote safety. So the state law does not violate substantive due process because they told you why it was rational. Also, you can see an equal protection problem because people who are not between 30 and 60 can't get the license. They are being treated differently. And the state is ultimately going to have to try to justify that difference in treatment. And that's an equal protection problem, which we will deal with later on. In fact, we can deal with it right now because this law treating people who are not between 30 and 60 differently, you're going to apply the rational basis test. We'll do this more thoroughly next week. But you can see you're going to apply the rational basis test because this law regulating who can drive the trucks doesn't impair any fundamental rights, right of speech or privacy or any of that stuff. It doesn't discriminate on the basis of gender. It doesn't treat suspect classes different, doesn't treat people differently on the basis of race or national origin. And so you're going to end up using the rational basis test. And you can see that the state has a rational reason to treat the people in these age groups differently because of their statistical studies of who drives more safely. Continuing, assume that a federal law prohibits employers from discriminating against employees on the basis of age. Wow. Well, it looks now like the state is treating people in one age group one way and people in a different age group a different way. So it looks like they're discriminating on the basis of age. And the federal law says don't discriminate on the basis of age. Well, you can see how that looks like that this state law went too far because it contradicts a federal law violating the Supremacy Clause. You also obviously have Commerce Clause problems, but right now just dealing with the Supremacy Clause because the state law says we're going to treat you differently based on age, and the federal law says don't discriminate on the basis of age. So it looks like the state law violates the Supremacy Clause and is void for that reason. However, you can make the argument that the federal law that says don't discriminate against people on the basis of age is not intended to prohibit bona fide occupational requirements. Let me explain what I mean. Let me suppose that I want to participate in a movie, and this movie has a part in it for a child who is 2 years old, and it's going to be a little child that's going to be pushed around in a baby carriage. And I want to be that child. And the movie company won't give me that job. And I say, you're discriminating against me on the basis of age. Just because I'm not 2 years old, you won't give me the job. Well, you can see that being 2 years old or around that age is a bona fide occupational requirement in that setting. And that's not discriminating if there's a bona fide occupational requirement. Other examples of that might be if, for example, I want a job and there's a Chinese restaurant, and the Chinese restaurant is doing everything they can to make that restaurant look and appear as though it is in downtown Hong Kong or downtown Beijing or someplace. And so they want to give you that experience of being in a Chinese restaurant. And I want a job there as a waiter. Well, you can see that's not going to work so well. And so being Chinese might very well be a bona fide occupational requirement in that setting. So there are situations where the distinctions are bona fide and they're not really a discrimination on the basis of age, and so or whatever it was. So in this case, if being between 30 and 60, you can argue might very well be a bona fide occupational requirement because they have these statistical studies saying that these people drive these high explosives trucks more safely. So you should make that argument. Next, Ned, who is 62 years old, is a driver for Ajax Trucking Company and engaged in interstate commerce, and they haul dynamite for construction projects, and they haul them into and through state A. Well, you see the problem. Ned isn't going to be able to get the license. So Ned is going to say, you are discriminating against me on the basis of age. You're going to say you are, Ned's going to say, first of all, your statute is unconstitutional because, see, if Ned is trying to claim the statute is unconstitutional, let's go through it. Ned's going to say, hey, state, you got a state law, and I claim your state law that says I can't get the driving permit violates the Constitution. It's a useless state law. How can I prove that? Either the state did not have the authority or they went too far. Did the state have the authority? Well, yeah, they're promoting safety. Got past that one. Did the state go too far? Well, Ned will claim that the state law violates the Supremacy Clause for the reason we talked about before. Federal law says don't discriminate on the basis of age. State law says we're discriminating on the basis of age. So Ned might claim violation of the Supremacy Clause. Ned might also claim that your state law violates the Commerce Clause. Now, Ned is also going to make some claims like equal protection, but we'll deal with that later. Well, we talked about already. Rational basis would be used and Ned would lose. But Ned will also claim that the state law violates the Commerce Clause. He says it violates the Commerce Clause. Is the state regulating commerce? Certainly, they're regulating trucking. That unquestionably is interstate commerce. You don't even need any of these new fancy devices to do that. If they're regulating interstate commerce, the federal government has a right to regulate interstate commerce as much as they want to. And is the federal government regulating interstate commerce too much? I mean, is the state regulating too much? Well, the state is not a market participant. Is the state directly discriminating against interstate commerce? No. The state is saying, we don't care whether your truck is traveling in interstate commerce or your truck is a local truck. If you want to drive that truck in this state, you need a special driving permit. So they're not picking out interstate commerce and treating it differently. In the case of hauling the waste stuff from the last problem, the city ordinance said you can't bring the waste from out of state into our waste dump. That's directly discriminating against interstate commerce. Here, State A is saying, we don't care whether you're hauling dynamite from in the state or out of the state or any of that stuff. If you're going to drive the truck at all in this state, you need a special driving permit. So we're not treating interstate commerce any differently than we're treating our local commerce. Therefore, we're not discriminating. If there's no discrimination against interstate commerce, we will balance the interest of the parties. The state will say, we have a very important state interest, safety. Remember, the only interests they are health, welfare, safety, and morals. And the state says, we got safety. We're trying to keep people from getting blown up. Very important state interest. Are we likely to achieve any of it? Well, yeah, we got statistical studies that show that what we're going to do is going to make things safer. Does the state have alternative ways to make the hauling of high explosives safer? Sure, they got lots of other ways they can make it safer. They can, for example, they can say that if you're going to haul high explosives, you can't go over the bridges except certain hours late at night. You can't go through the tunnels except certain hours. We lower the speed limit so you can only go 50 miles an hour or something. We can even require that you have a lead car with flags and stuff or something. So then we can require these trucks to not even go into the downtown urban areas, to stay out on the country roads. So there are other ways that you can make the hauling of high explosives safer. So you see that there are alternatives. And so that's how you would list this part. How much does this interfere with the free flow of commerce? Well, you just described what would happen to a trucker who arrive there out of state, from out of state hauling high explosives, and they don't have the proper license, it would be a major disruption of interstate commerce. That's how you analyze the state interest. That's how you'd analyze the federal interest. We don't care what your conclusion is. So we're about wrapped up with this problem now. The rest of the material is pretty self-explanatory. They ask you, how should the state rule on the motion? The other thing that the state finally asks is there's a motion to dismiss on the grounds that the state A says there is a motion, state A made a motion to dismiss Ned and Ajax's law. They made a motion, Ned and Ajax's lawsuit, motion to dismiss it on the grounds that the state A law has not yet been interpreted by the highest state court. And the highest state court might be able to interpret this law in such a way as to prevent it from being unconstitutional. Well, that is your abstention doctrine. They're saying to the federal courts, you should abstain from even hearing this case until our highest state courts have tried to save the law. Well, we look to see, first of all, is this in fact a new law? Yes. Has it been interpreted by the highest state court yet? No. Can the highest state court save this law? Well, you look for this law and see if there's any way the state court might be able to interpret it so as to save it. And but even so, even if you think the highest state court ought to be able to try to save this law, please notice that the federal courts, under the abstention doctrine, the federal courts do not dismiss this case from the federal courts. Ajax and Ned file the case, and they will stay the proceedings, saying, okay, just hold everything up right here, and you people go over to state court, let the state court see if it can save the law, and then come back and see what they said, and we'll tell you whether it's unconstitutional or not. So the state is asking the federal court to dismiss. That's wrong. The federal court will just stay the proceedings under the abstention doctrine, not dismiss. Finally, don't forget to address standing and state action in all con law problems. In this problem, for example, Ned has standing, obviously. Ned has individual standing. Ajax will have individual standing or third-party standing. And there is state action because the state law was passed by the state. Ned has individual standing because Ned's been injured because Ned can't drive in the state anymore. Causation, redressability, all those can be satisfied as to Ned. As to Ajax, Ajax can say that we are injured because we can't hire drivers over 60 or under 30 anymore. That will disrupt our business because a lot of drivers we can't hire. Causation and redressability would be satisfied. Ajax can also claim third-party standing, saying that that Ajax is injured by a violation of Ned's constitutional rights. Ned is injured. Ned has standing because Ned is the person who is injured, and if you get third-party standing, if first of all Ajax is injured because of a violation of Ned's constitutional rights, that's probably true. Ajax is injured because they can't hire people like Ned anymore. So Ajax is injured, and furthermore, Ajax now is being required to discriminate on the basis of age. They don't want to do that. So Ajax is injured by a violation of Ned's constitutional rights, and they would argue that it is unlikely that Ned himself would take on the Constitution, even if he is going to take on the Constitution to try to drive in this state. Ajax is in a better position. They're a company to afford that kind of litigation. So it'd be difficult, unlikely, that Ned would be able to litigate this, or if he could, Ajax can do a better job. So Ajax may get third-party standing, Ajax may get individual standing, NED gets individual standing, and clearly there has been state action. And that's how you would analyze these questions. All three questions involve these issues about these issues. Some of them involved, one involved the abstention doctrine, all of them involve standing and state action. You could have volunteered rightness and mootness if you wanted to, saying, for example, in the case of NED, that the case was right because NED has applied for a license, has been denied. The case is not moot, it's not too late. So you could volunteer rightness and mootness if you want to. 11th Amendment, you could use the 11th Amendment argument here because NED is suing the state in federal court. And the 11th Amendment says you can't sue the state in federal court, but the 14th Amendment says you can sue them in federal court if you're claiming a violation of the 14th Amendment, and you can get an injunction or declaratory relief, but you cannot get money damages. And NED and Ajax are both looking for probably declaratory relief. And NED is claiming a violation of the 14th Amendment because NED will claim violation of equal protection. That is how you would analyze these three questions. We went through them talking kind of fast at the end, but of course you can slow down and repeat the video, but I needed to do that so we could more or less finish on time. That's how you would analyze those three questions. Our next class on con law will be a class where we will look at the individual rights, the 13 or 14 individual rights, and understand how to deal with those kinds of questions. And that is the end of this lecture.